Good afternoon, everyone, and thank you for joining us today. On behalf of Ferdem Attorneys at Law, I'm delighted to welcome you to this important webinar titled Corruption Risks, What Turkish Companies Can Learn from International Enforcement Actions. Today's discussion is hosted in collaboration with the Turkish Trade Compliance Sanctions Network, TTCSN, and HCR Law, bringing together insights from Turkey and the United Kingdom to explore how companies can strengthen the compliance and manage corruption risks more effectively. It's a great pleasure to have Ben, a partner at HCR Law, with us today. Ben is an experienced compliance lawyer who has advised numerous multinational clients on anti-bribery and corruption investigations, corporate governance, and enforcement matters across multiple jurisdictions. Ben, thank you very much for joining us. And let's start by setting the stage for our audience and introducing yourself first.
Thank you, Safak, and welcome everyone. I'm really pleased to be invited to speak to you today. So I'm a partner in the London office of HCR Law. We're a full-service UK firm with 11 offices around the UK, and I specialise in sort of white-collar crime, compliance, and enforcement matters. In the chat, I've put a link to the bio from our corporate website, so you can have a look at that, and that has all the contact details and a link to my LinkedIn profile as well. So yeah, really looking forward to having this discussion with you this afternoon on matters that I find really interesting, and hopefully I can pass on some my views and thoughts on how corporations can deal with sort of white-collar crime compliance risks.
Thank you again for joining, Ben, and for the introduction. Ben, to start, I would like to ask, how has the corporate criminal liability landscape in the UK changed, particularly in comparison to the United States, with a focus on corruption issues?
Okay, so firstly, I would say the UK sort of anti-corruption landscape is definitely less mature than the US. Just in nature of it, the US Foreign Corrupt Practices Act, as their anti-bribery and corruption legislation, was from 1977, whereas the UK Bribery Act is 2010. So that can show you that America definitely had a head start on their sort of anti-bribery and corruption compliance programs and enforcement programs. So definitely we're not as mature in the UK as in the US. But that being said, in the current climate, the US is probably less predictable to deal with how they currently are dealing with, especially on the foreign corruption side of things, because when Trump came back into power, he put a hold on foreign corrupt practices investigations. That has now sort of lessened, and they're sort of kind of back on track. But I think, and I'm not obviously not an American lawyer, so I'm not best placed to advise on that. But I think from speaking to American colleagues and just sort of seeing the memos that come out of the DOJ, I think it's probably more down to, if the US have an issue with you, they will pursue enforcement, but it may be more of a, they'll be picking and choosing their matters. But what I can say is, in terms of the UK, the landscape has shifted quite a lot in the last 15 years. So our UK Bribery Act is 2010, and that has been the start really of using criminal legislation to shape corporate behavior, business ethics, and compliance programs. So what we now have is the failure to prevent corporate offence under the UK Bribery Act. So that started with bribery and corruption. Then in 2017, we had a Criminal Finances Act that introduced a failure to prevent the facilitation of tax evasion. And then as recently as 1st of September this year, we have a new piece of corporate criminal legislation that introduces a corporate criminal offence of failure to prevent fraud, and that covers a wide range of fraudulent conduct, including tax fraud, insider dealing, and an array of fraud offences. So what we can see from that is that the corporate criminal liability landscape in the UK really has changed over the last 15 years, where now for economic crimes, we have these corporate offences of failure to prevent, and we'll go on to it, but that brings into play the changes and the importance of compliance programs within organisations. Also, what we have done, and again, I can use this to do a comparison to the US, is in the UK, in December 2023, we changed our corporate criminal liability. So historically, in the UK, the threshold and the test for corporate criminal liability was what we called the direct in will and mind test. So that was if someone within an organization that was sufficiently senior, that was the direct in will and mind of the company, committed a economic crime offence, then the corporate entity itself could be criminally liable. In the US, they don't have that. They have a vicarious liability, corporate criminal liability system. So anyone in the company committing a criminal offence that benefits the company can attach criminal liability to the company. So you could have a scenario, unlikely, but just for illustrative purposes, if a caretaker or janitor in a American company commits a fraud that benefits that company, that member of that employee could attach corporate criminal liability on that company. So the UK for a long time had this real gap in terms of our levels of corporate criminal liability. So the change that came via legislation in December 23 was to change that test to bring a lower threshold for attributing corporate criminal liability by the actions of employees to a senior manager test. So anyone that is a senior manager within a company, their actions, if it benefits the company, can attach corporate criminal liability. So that's been a big change. And when it comes to who is a senior manager, that's a question of substance rather than form. So it's not just purely they are a senior manager in their job title. It's what are they doing in terms of their employment? How can they bind and the company by their actions? What authority they have to act on behalf of the company? So in terms of a compliance shift, that's what we're saying to sort of UK companies. You really now need to be mapping out your organization, working out who is a senior manager for the purposes of our for corporate criminal liability for economic crime offences, so that you can raise awareness within your organisation to those that fall within that category of your workforce, but also where necessary ensure any additional training that you, as part of your compliance program, you offer to that category of employees. So that's where we have. One thing I would say in terms of just going back in terms of where maybe the US currently may not be as active in their sort of role as global policeman for foreign corruption matters. As of March this year, the UK, France and Switzerland formalized a anti-corruption alliance. So that's effectively a working task force to increase collaboration and cooperation between the UK, France and Switzerland for anti-corruption matters. So that was of March this year. We wait to see in terms of what that will lead, what that mean in reality in terms of potential investigations and enforcement. But that was very much a sign, considering it's a couple of months after Donald Trump come back into power, that the UK, the French and the Swiss said, well, we are going to formalise an alliance to tackle anti-corruption matters. So that shows that in terms of certainly in Europe, there is a desire to continue multi-jurisdictional, extraterritorial bribery and corruption investigations.
Mm-hmm.
That is something that needs, multinational companies or companies, with trading arrangements elsewhere in the world need to be aware of.
That's a great opening perspective indeed, and it's a very valuable explanation. Thank you for that. Moving to the global trends, what common compliance failures or risk factors have led to major enforcement actions worldwide?
Yeah. Okay. So what I can do is the worldwide. I'll hold off on the sort of cases for a minute, if that's okay. So what I'll do is sort of touch upon, because I've gone through the UK anti sort of corruption legislation. What I'd like to do is sort of how that has sort of changed the compliance landscape. So
Okay.
I'll bring in those sort of principles, and then what I can say is, drawing on that, we can then see some of those areas where there has been some enforcement, and I can touch upon some of those cases. So one thing I would sort of say from the outset is the corporate criminal legislation is not necessarily purely to drive enforcement. So yes, investigations could follow, and criminal enforcement and cases will follow, but part of it is really driving cultural change in terms of how companies do business, when they're doing business abroad in different jurisdictions, sort of driving that good corporate behavior and business ethics. So that's certainly the driving force behind the corporate, or what I would say is that behind the corporate criminal legislation. It's not necessarily about, right, okay, we're bringing in new corporate criminal legislation because we want to prosecute and bring cases against companies. I don't think that's necessarily the motivation behind it. I do think the motivation is to increase corporate accountability, good business behavior, and good business citizens. So what the UK has really sort of pushed, and they have done so by way of guidance, is they've developed what they call the 6 principles of effective corporate compliance. And that the 6 principles are, and I'll sort of list them, and then we can touch upon some of them. So they are: principle number 1 is top level commitment, and you may have heard or be familiar with sort of concepts like the tone from the top. So that is basically saying, look, it's important that the senior people within an organization are committed to their compliance programs. And when they say commitment, that is really, applying and allowing the right level of time, resource, and other resources to build out a compliance program, and that is something that the top of the company is committed to. Second principle is risk assessments. So that is, to my mind, the starting point of a building out a compliance program is conducting whether that be anti-corruption and money laundering, fraud, sanctions. You risk assess your business, conduct a risk assessment, and that is from the output of your risk assessment work that leads you to the third principle, which is putting in place proportionate risk-based prevention procedures. So like I say, in the UK, the defence that a company can raise if they are accused of failing to prevent corruption, or failing to prevent tax evasion, or failing to prevent fraud within their organisation, is to demonstrate to law enforcement agencies that are conducting the investigation, well, yes, corruption may have occurred. However, as an organisation, we take compliance seriously, and we have proportionate, risk-based, adequate policies and procedures in place to prevent bribery and corruption. So if you can demonstrate that to the satisfaction of the law enforcement agency, that would actually be a defence to potential criminal charges being brought against the company. So then moving on to the fourth principle, that is due diligence. And due diligence, as we all know, that is very important in managing your third-party risks. The fifth principle is communication, and communication includes training. So again, that is how you roll out training to within your organization, whether that be your bribery and corruption training, money laundering training, and things like that. And again, that's all should be risk-based. So the training that you offer within your organization to the entirety of your employees might be different to those that you've, through your risk assessment, you've worked out, well, actually, that person in the procurement team or the sales team who are conducting deals and activities cross-border in potentially higher risk jurisdictions or in higher risk sectors, then you may tweak your training program to give enhanced training in companies where you are working in high risk sectors, or you've identified employees within your workforce that are working in higher risk parts of the business. And then the last principle of the effective compliance program is monitoring and review. So it's how do you monitor what's happening in your company and reviewing record keeping and things like that. So what the UK government really in their guidance for all these sort of corporate criminal liability offences, that's what they're pushing out, is that when you're building out your compliance program, work to meeting and covering off and dealing with these 6 principles. And if you work to that template, you are in a good place to building out an effective compliance program to mitigate your risks of your there being sort of issues down the line. So when it comes to failures and the risk factors and sort of major enforcement actions, definitely what I would say from looking at the cases, certainly coming out of the UK, or the cases that has been cross-border, where it's a UK collaborating with the Serious Fraud Office collaborating with the DOJ and things like that. What we see time and time again is the biggest risk factors that organizations need to deal with, and where they definitely need to play sort of close scrutiny to, is their third-party risks. If you can manage your third-party risks, you are really starting to be in a good place. So that's where you really need to be looking into your third-party due diligence. Who are your associated persons? And then also looking into your contract terms and conditions with third parties. So I definitely think that's a really good starting place. And in the current world, with ESG as well, supply chain, all these sort of things go back to how an organization manages their third-party risks, whether that be their supply chain risk, all those type of things. So I would say, in terms of building out compliance programs, looking at that due diligence side of things, really do pay some attention and put adequate resources into your due diligence with third parties that you're contracting with, you're doing a joint venture with, or all those sort of things. It's because if you can manage, like I say, if you can manage your third party risk effectively, you're in a good place. So let's talk a few sort of war stories and sort of lessons from enforcement cases when looking at sort of corporate criminal liability. What I'm going to do is sort of highlight 2 particular cases that I think that deal with these. And one of the things, how the landscape has changed in the UK, again, sort of modelling a little bit of the American practices, is in the UK we've for a similar sort of time now, for about sort of 10-15 years, we've had the option for deferred prosecution agreements. So that is where the Serious Fraud Office in the UK can enter into a deferred prosecution agreement with a organisation where they've accepted liability, but rather than being prosecuted through the criminal courts, they've cooperated and negotiated a deferred prosecution agreement with the Serious Fraud Office, with some judicial oversight, and then the High Court will ratify a deferred prosecution agreement, which will lead to financial penalties, disgorgement of profits, and also other remediation steps that the company would have to comply with as part of the conditions of the deferred prosecution agreement. But just to bring it, I'm going to talk about 2 cases that sort of highlight some of these things. One was a deferred prosecution agreement, and one was not, because I think it leads to a potential discussion about how companies need to think about their approach to cooperating or not cooperating with law enforcement agencies on these issues. So the first case, which people may be aware of, is the Airbus case. So the Airbus was a global bribery and corruption case, and the deferred prosecution agreement settlement reached with the US, the UK, and France was around $4 billion in terms of global settlement across those three law enforcement agencies. And the issues there for where the bribery and corruption was all to do with use of consultants, brokers, and agents. So a reason I wanted to highlight that case is because it goes back to that third-party due diligence. So and sort of getting on top of that, because the majority of the big global bribery and corruption cases, it has been centered around the use of intermediaries, brokers, agents. And so again, I just really think it underlines what I was saying about managing those third-party risks. The second case I want to bring to everyone's attention, if they're not familiar with it, is the Petrofac case in the UK. That one differs because it wasn't a deferred prosecution agreement. The company in that case actually pleaded guilty and went to court and pleaded guilty. The fine to the company following a guilty plea for the bribery and corruption offences was £77 million. The reason I wanted to raise that case is because that's an example of a case that was triggered by a whistleblower. Okay, so there was a whistleblower within the company, and the whistleblower in that case was actually working out of Saudi Arabia for Petrofac, and the culture within the company was such that rather than them, the whistleblower bringing their concerns about the bribery and corruption issues that they were aware of within the organization, rather than bringing that attention to a compliance officer or a general counsel or reporting that internally, the whistleblower, fearful for repercussions in terms of their employment and the issues that they may face, decided to leave Saudi Arabia, fly back to the UK, and reported the matter to the Serious Fraud Office in the UK. That then triggered a Serious Fraud Office investigation, and ultimately the company pleaded guilty and paid a fine of 77 million. So the reason I wanted to raise that as an example of enforcement cases, because that's an example where the sort of culture within an organization, the tone from the top messaging about compliance, which inevitably should include your whistleblowing program or your speak up program, is really, really important. Because if there was that sort of compliance culture within Petrofac at that time, the whistleblower may have felt comfortable to raise the issue internally and have sort of confidence that their concerns regarding the bribery and corruption issues would be taken seriously, and that the company would act upon that. It could be a completely different landscape, because obviously if you're in an organization, you would far rather, if issues are uncovered, far rather have the opportunity to deal with them internally. That still may lead to a self-report to a law enforcement agency, but you've got control of finding out the information yourselves, doing your internal investigation, your internal fact find, getting to understand what the issues really are, and then make informed decisions about what you should do. And also you're avoiding that situation where a whistleblower doesn't feel they can report matters internally, and they are going either to, and we see the examples of this as well, to investigative journalists or straight to the law enforcement agency themselves. So I want to raise that one, because that again, it just shows that the really sort of dealing with and building that compliance culture within an organization can really help you manage those risks, and also, like I say, be able to effectively control those issues. So yeah,
please go ahead.
Yeah, so I'm going to say, I mean, I think what the question then is sort of cooperation and with law enforcement, and what does that look like? So in the UK, we had recently had a new serious fraud office guidance in respect of corporate cooperation. Okay, so that is a document where companies can look at and sort of see what they say, and that goes to sort of issues of when companies should self-report, at what time, is it a matter of reporting issues straight away, and what they can expect from interactions from self-reporting issues to the serious fraud office and things like that. What does cooperation look like? And it's not the same for every type of case, but there is guidance there, and I think really it's helpful. It doesn't give all the answers to a company that's facing with looking at a corruption issue within their organization, but it helps them think, right, okay, as a legal team, in-house legal team with your external counsel as well, okay, let's do the initial fact find, where are we, and then it gives you that blueprint to think about, okay, is self-reporting something that we want to consider? And if so, at what stage? Because it can depend on a case-by-case basis, because certain investigations and the law enforcement agency don't necessarily want the company to do too much of the investigating themselves. But at the same time, you want to have done a sufficient amount of internal investigation so that you are making your decisions in an informed way before you make any sort of decision as to what level of cooperation or self-reporting you want to do. Because there has been cases as well in the UK where actually, on reflection, companies were probably too quick to self-report, and actually they then had to row back from the position of sending in a PowerPoint presentation to the serious fraud office saying we think we're culpable of bribery and corruption, when actually they may if they'd taken their time over that, they and conducted a more rigorous fact-finding exercise in the first instance, they may have actually got to a place where they didn't feel they needed to self-report. These are all fact-based, but that whole question of whether to self-report or not self-report is not straightforward, and it's not an easy answer. There's a real balancing exercise that a company needs to think about very, very carefully, across sort of a number of different stakeholders to determine whether that sort of that step is the right sort of step. It's obviously different if the investigation by a law enforcement agency has been part of a proactive investigation, then the company is not in that, that the investigation is live and it's afoot. So then the question is merely then about the level of cooperation the company wants to, in terms of engaging with that investigation.
Mm-hmm.
Yeah.
That's an important clarification. The recent SFO guidance seems to make cooperation and transparency a decisive factor in enforcement outcomes, which is a useful lesson for all jurisdictions, including ours. And for the examples like the Airbus and the Petrofac, it really highlights how tone from the top, whistleblower response and third-party oversight continue to define how regulators judge corporate integrity. I want to now bring this discussion into the Turkish context, and many Turkish companies are involved in international projects or joint ventures, and What do you see as the main cooperation risk they face in these cross-border operations, and how can they ensure their compliance programs meet international standards?
Yeah, it may not come as a surprise. As I mentioned earlier, I think that's where I really do think getting on top of your third-party due diligence is a really good starting place. And as well, I would say, if you are working in multiple jurisdictions, I think actually the UK's guidance on effective compliance, or even actually the companies like Transparency, organizations like Transparency International also have their guidance on effective anti-bribery and corruption compliance as well. So I think really it's a good place to sort of source that information that's available, so that you're almost looking at your compliance program from a best in class, best practice approach that will give you that comfort that you're building a compliance program that's going to not only meet requirements within your own jurisdiction, but if you are working or in joint ventures in the UK or the US or in other jurisdictions, you are sort of building out your compliance program using the guidance that's available from in those jurisdictions and from organizations like Transparency International to really build out that compliance program as best as possible. And like I say, with the UK, the theme that we are seeing, whether that be for bribery and corruption, anti-money laundering, sanctions, tax evasion, it is these core 6 principles that time and time again they're using. So I think that what that helps with is that when you're building out your compliance program, if you're adopting the 6 principles across all the risks within your organization, the financial crime risks or environmental risks, I mean, we're seeing a lot more concern about, like we say, about supply chain risks and environmental crimes and things like that. So again, if you apply those principles across the entirety of your compliance brief, not only will you get your compliance program where you need to be, but you'll start to build in some efficiencies and proportionality to your compliance program, because you're sort of taking a consistent approach rather than just purely looking at bribery and corruption. But if you sort of broaden it out to, like I say, your other financial crime risks, it helps you create some efficiencies in terms of the resources that you're applying to your compliance program. So I definitely think that's a good place is looking to those pieces of guidance and taking on those principles.
That's an excellent overview. Thank you. And your point about third-party due diligence and aligning with 6 compliance principles is particularly relevant for Turkish companies expanding abroad. In that same context, how critical is supply chain and third-party due diligence in mitigating corruption risks?
I think they go sort of hand in hand, really, and that's why I sort of put it under the banner of managing your third-party risks, and then that includes your supply chain risk, is because quite often, the conduct, the sort of wrongdoing conduct within your supply chain, or they all kind of go hand in hand. If there's sort of, I don't know, forced labor issues, that there might be forced labor within your supply chain, but actually when you look at that, within your supply chain there might be issues about how companies within your supply chain have obtained licenses to act certain activities, and that's when you think, well, actually they've obtained that license by corruption, in terms of so I think they're all hand in hand, which is why I do think sort of applying those principles and really saying, okay, well, not just thinking at one element, what my bribery and corruption risk, my supply chain risk, my sanctions risk. It's just really looking at what is your compliance program for due diligence and managing third parties as a whole within your organization. Yeah.
Thank you for stressing that, Ben. And continuous monitoring rather than one-time due diligence is clearly key to maintaining compliance integrity in dynamic commercial environments. And let's move to the practical implementation. What practical measures can companies take to strengthen their anti-corruption frameworks beyond having written policies? This is what we are always facing in the sanctions compliance as well.
Yeah, this is a really important one, and it's one that I'm probably going to get on my soapbox for, is because what we often see, and what is really not what good looks like, is a situation where a company will have a written bribery and corruption policy document, and they will have that, and there's many templates available, and going back to the 6 principles, having proportionate risk-based policies and procedures is 1/6 of the 6 principles. Okay, so which is why I say that for me the starting point is always the risk assessment, because if you have a situation where the Serious Fraud Office in the UK or your equivalent will come to you and say, look, we've had a whistleblower come to us and we're considering opening up a bribery and corruption investigation into your organization. And they may, one of the first things they may say is, can we see your bribery and corruption policy document? And you may have one, and you may hand that over. But quite often you see with it, certainly in these templates that are available, is that you'll get the sort of bold pronouncement that such and such company takes a risk-based approach to bribery and corruption, which is right. Is that and if you that is the way you should do it. But if you merely have a policy document and that's the sort of the height of your compliance program, and your policy says, oh, we take a risk-based approach or a zero tolerance approach to bribery and corruption, and the first question the law enforcement agency has asked you is, can we see your policy document? Their very next question will be, oh, that's great to hear that such and such PLC takes a risk-based approach to bribery and corruption compliance. Can we see your risk assessment document and your underlying risk assessment material where you have assessed the risk in your business, so that you can then draft your policy and consider your procedures and your monitoring and what levels of due diligence you're doing? Can we see your risk assessment? And that goes to the heart of why we all say in the UK that the tone from the top should be probably principle number 2, and actually the principle of risk assessments should be principle number 1 for me, because that is the foundation for any effective compliance program that is going to meet that scrutiny of, how effective is it? Have you really thought about what the risks are to your business and built out a compliance program to meet your risks? And that shouldn't be something that companies think, well, that's going to be more onerous. We just thought we needed a policy document that could be on our intranet and part of our mandatory training for all members of staff and things like that. We thought that the positive to conducting a thorough risk assessment is because that's how you can then achieve proportionality to your compliance program. Because you can say, well, actually, we've conducted a risk assessment process, and in our business, in our sector, we think, having done the risk assessment, the bribery and corruption risks, or money laundering and fraud risks, are low in these following areas. Therefore, in terms of our resources and in terms of our program, we are going to concentrate on the areas where we have deemed the high risk areas. That's not to say you ignore other areas of risk, but that's where you can say, well, from our risk assessment process, that we are going to concentrate on these areas, and we put more resources into these areas because that's where we need to minimize and mitigate risks. So actually, by doing that step of doing that risk assessment, you can actually build in some efficiencies, and so it benefits on that side as well. And that's where, for me, that sort of tone from the top comes in, is when you work with an organization that sees these types of compliance issues as an investment in the company rather than a cost to the company. Because when you sort of sit down with board members or general counsel, and you really see that, and you sense that they do see that compliance as an investment in the company, to protect the company, rather than, oh, this is an additional cost and a real resource drain to the company. That is really what we want to see from the tone from the top, because, and it's sort of a phrase that's used all the time, isn't it? Is prevention is better than the cure. Well, if you think sort of building out an effective compliance program is a drain on your resources, and a cost to your business, just speak to somebody within Airbus that was then caught up in a 6-year investigation that's costing them extortionate amount of time and resource management time, not to mention the cost on lawyers, and then ultimately ending up in a $4 billion worldwide settlement. Well, actually, investing in the business, in the compliance program, is a far better way to protect you financially, and also in terms of management time and things like that. So that's what I would say is really getting that message across, that compliance is an investment to protect your business. It's not a cost to it. Yeah.
That's a very good point. Thank you. And it's refreshing to hear that the compliance is about substance over form, and that policies alone do not work without underlying risk assessments and meaningful application.
Yeah, I mean, that's it. Is sort of, sorry, just to add to that, is you've got to see compliance as a living, breathing thing. Yes, your policy document will be dated March 2025, and that's there, and but it's that monitoring, review, all those sort of things. It's not a snapshot in time. It is a living, breathing thing, an effective compliance program.
Yeah. And what about the boards and the senior management? How can they demonstrate the genuine top-level commitment and support a sustainable compliance culture?
But it is that, I say, it's that the top-level commitment is one of the principles, but it goes back to, it's that messaging and that communication, and it's providing the organization with the right level of resources to deal with it, and that is the key. It's that mindset of, this is important to the organization, it protects the organization, and we are going to apply the right level of resources so that we can embed an effective compliance program.
That's a strong reminder. And I completely agree that when management sees compliance as an investment rather than a cost, the entire organization follows that example.
Yeah.
Looking ahead, what future enforcement trends or emerging risk areas should Turkish companies prepare for?
I think definitely we got to, it depends on your company. I mean, if your company is working internationally, you've got to be aware of the extraterritorial reach of other jurisdictions. So coming from a UK perspective, there's extraterritorial reach in our UK Bribery Act, in terms of foreign bribery, and also the associated persons. So if you are an organization with a UK subsidiary, or if you are a Turkish subsidiary of a UK headquartered, I mean, you've got to think about that. And that's, again, it's a mapping exercise. Is where when you're doing that sort of risk assessment, where are your risks? So, for example, under the new UK legislation regarding failure to prevent fraud, if you're an organisation and you've got UK employees not working in the UK but working in your jurisdiction, and they commit fraud, then that's within the UK reach. If there's a UK nexus to the fraud, then that could bring that fraud within the UK reach as well in terms of extraterritorial reach for enforcement. So, and that could be for any sort of reason. So if you think a situation, if there's a fraud happening in a subsidiary in Turkey, but the UK headquarters is there, but actually all the conduct is in Turkey, and there's no UK nexus in some way, but actually money flows through the group structure, means that the benefit of the fraudulent conduct in Turkey, that the proceeds of that fraud end up being moved into the profit and loss group level, well then that creates risks in the UK. Not potentially money laundering, but also it's fraud for the benefit of the UK company because at that group level. So I think that's, again, it comes into that sort of risk assessment and that work that you're doing, mapping is working out where your risks are. And like I said, certainly in terms of trends, maybe there isn't a big appetite at the moment from the US to open foreign enforcement actions. I think that's probably, I think it's more going to be on a case-by-case basis. If the DOJ and the US government don't like the activity they're seeing, they will investigate it. But what we have seen is if there has been a slight step back from the US in terms of being, global corruption police officers, the statement of intent from the UK, from the French, from the Swiss in terms of the alliance that they entered, formal alliance they entered in March this year, just goes to show that actual, multi-jurisdictional extraterritorial investigations are still part of the landscape of these law enforcement agencies in Europe.
Thank you, Ben. So the new failure to prevent fraud offense in the UK is a fascinating development and certainly a sign that corporate accountability will continue to expand internationally.
Yeah, what it's I just want to touch on that, which is why we are thinking in the UK that this is likely to be more impactful than our UK Bribery Act, because the UK Bribery Act was purely looking at bribery and corruption, which is obviously serious issues, but they're quite narrow in terms of the actual conduct. Under the failure to prevent fraud offence, corporate criminal liability offence in the UK, there's a whole list of offences in a schedule, and the conduct is really wide. So where we're advising companies there is what you really need to do is almost do an exercise of wargaming in each of your department and saying, right, okay, in our finance department, where is the sort of economic crime risks, fraud risks there? And that could be false accounting or false reporting and things like that. And then you look at your sales and procurement team. You say, okay, well, where are the fraud risks there and things like that. So it really does make you think. You can't just sort of look at compliance here and do a desktop exercise from your risk compliance officer doing that. What they really need to be doing is looking at each sort of either service line or work stream or department, and looking and speaking to the senior people within that department and saying, okay, well, where do you see the fraud risks or the economic crime risks within your department? And again, that's all part of that risk assessment process of speaking to people at the business, working day to day and getting their views on where your risks of your business is. And again, that if you're documenting that as part of your risk assessment process, if you ever do have issues, that is really good material that you have within your compliance files and your review documents and your reporting documents that really help demonstrate that you do have an effective compliance program, demonstrating that tone from the top, and that this is an effective compliance program, which then gets you the protection. Because let's face it, there is that we all talk about zero tolerance, but actually it's very difficult to achieve that, and there's always underlying risks. It's very difficult to mitigate and eradicate risk completely. So you can still have a very effective compliance program, but still you may have issues within the corporate lifetime of that organization that you're going to need to deal with. But what you want to do is be able to actively demonstrate, if called upon, that as far as you've done, you've embedded a compliance program to mitigate as much as possible the risks to your business in your sector, dealing with the service lines and product lines or whatever, in terms of your organization, because you've done that job of working out what are your high risks.
And my next question is about the technology, which is in the middle of our lives. So that it's increasingly shaping the compliance practices as well. And how do you see the tools like data analytics and monitoring systems transforming anti-corruption programs?
Yeah, that's right. I mean, we can't shy away from technology, and we don't want to. I mean, we want to at least move with technology. I think we all find it a bit overwhelming trying to keep on top of technology, but in terms of compliance, there is definitely a vast array of tech tools that can be used, and that can help you with your transaction monitoring, your third-party screening, all those sort of things as part of your due diligence, and that goes into the review and record keeping and monitoring and reporting. So I definitely think that, to me, if you're looking to use tech within your compliance program and your compliance framework, I'd go to use those tools and try and use those in the first instance. Yeah, I think that's where I've seen the biggest sort of developments is in those monitoring and transactions and screening tech tools and applications that are available to organizations now.
And
I mean, and again, I think quite a lot of organisations are now used to that because they've had to be in terms of sanctions screening, especially since 2022. So yeah, there's lots of good tech applications available for those screening process of due diligence, which again goes to what I say is get on top of your third-party risk, and tech is a real there's a lot of assistance that can help with that side of things.
And it's encouraging to see how technology is moving from being a compliance burden to an enabler for effective oversight and prevention.
Yeah.
Finally, I think we are almost down to timing. And what advice would you offer to Turkish compliance officers who wish to align with global best practices while staying consistent with Turkey's or other regulatory environments?
Yeah, I think it's that thing is just don't shy away from the compliance and have that mindset of this is to protect our business. So this is an investment in our business. I mean, and we all see it, those third-party risks. I mean, outside of bribery and corruption, that now the risks of a cyber attack, that's coming from criminal actors. We are now all seeing the real value. I mean, we've had the big problem with Jaguar Land Rover in the UK. It's cost them billions. Having been the victim of that cyber attack. So we now see this on a weekly basis, really, these high-profile cyber attacks. So that what that tells companies is really you need to invest in your cybersecurity, in your compliance program there, and I see the wider economic crime, bribery, corruption is exactly the same. It's a protection to your business. So again, what I say is you've got to be mindful of your own obligations in terms of the Turkish rules, laws and regulations, but going to organizations like Transparency International as to see what guidance they provide is a really good place, because that helps you. If you start from that, sort of what is best in practice in terms of a global compliance program, what does that look like, and you can embed that for your organization. And then even if you're not necessarily in joint ventures or working across borders in multi jurisdictions. But if you've got ambitions too, if you can embed a compliance program that meets those international standards from the outset, that is a really good investment in your company, because then what you're doing is you're just keeping on top of things, modifying things, reviewing things, and adding to reacting to changes in local legislation or regulations. But your foundations are rooted in what is sort of international best practice.
That's an excellent note to end on.
Yeah, because I think again, you get the efficiencies at the back end. If you invest the good base, the foundations of a compliance program, and invest the resources in doing that well, you then get the benefits of efficiency down the line, and that's where the resources that you have to apply to your compliance program should then get to a really nice proportionate level, rather than feeling that actually you're being overburdened by compliance and it's taking up too much time and resources. It's setting those foundations when building out your compliance program in the first instance.
And the following the 6 principles as a foundation makes perfect sense. It's a model that translates across borders and industries. Ben, I would like to thank you for such a thoughtful and comprehensive discussion. You have provided our audience with a clear picture of how international enforcement standards are evolving and how Turkish companies can align with these expectations while maintaining compliance under the local laws. And I will be grateful if there is any question to answer. If there is any question, you can answer your questions on the Q&A box. And on behalf of Herdem Attorneys at Law, I also wish to thank HCR Law for supporting these events. And finally, thank you to all our participants for joining us today. We hope this discussion will serve as a valuable reference for building stronger, more transparent and globally aligned compliance frameworks in Turkey. And if there is no further questions or any remarks, then I will close the session.
Okay. So thank you very much for inviting me. As I say, my profile's in the chat. If anyone wants, after the event, wants to ask a question, they can connect with me on LinkedIn. Send me a message on LinkedIn. We can have a chat. It's really, really good to have these discussions.
Yeah. Thank you very much, Ben. Thanks, everyone.